You're having a party at your house. Everyone's having a good time. One of your guests comes up to you and asks for a little more wine, and you pour them some. You're being a good host, and you want everyone to have a nice time. Good idea? What if I told you that pouring that last glass of wine could actually land you in legal trouble? I'm Shounak, rhymes with Sonic. I've been a plaintiff's litigator for almost 10 years. That means I represent people, usually against governments or big corporations. I love the law, and I love fighting for people every single day. I'm going to tell you about the 3 ways in which you, as the host of a party, could potentially have some liability, either because of the amount of alcohol that you serve or who you serve it to. Your house may have some hazards in it that may cause injury to some people, or you might have invited someone that you should have known was going to get into that fight. Serving alcohol at your party could get you into trouble in a couple of different ways: overserving or serving minors. The idea of liability for overserving somebody is pretty well established in the law. There are these laws called dram-shop laws. Now, a dram is a measure of alcohol. It's a really old term. It's less than a shot, and it's what alcohol used to be measured in drinks, at least in Western countries. Dram-shop laws are laws that have existed in various states to make sure that licensed institutions that serve alcohol, like bars, restaurants, they can be liable if they overserve their patrons. If somebody is intoxicated and a licensed institution serves them alcohol, even though they're visibly drunk, they're visibly intoxicated, then they could be liable for something that person goes off and does as a result of being intoxicated. The classic example is someone is clearly intoxicated at a bar serves them anyway, that person goes, gets in their car, drives, and then injures or kills somebody. Who's liable? Courts in various states have found the bar liable, not completely liable, but certainly partially liable, because it was reasonably foreseeable that serving an intoxicated patron additional alcohol was foreseeably going to result in them going off and doing something that could cause injury or death to another person. If you've ever been at a bar and you've been cut off, it's probably because the bar has a very good idea of the potential liability that can arise from serving you. This concept can apply to private parties too, and these are termed social host or social responsibility laws. While the specific laws differ from state to state and jurisdiction to jurisdiction, the through line is foreseeability. Is it reasonably foreseeable that serving an intoxicated person would result in them doing something reckless or something that could cause injury to another person? These laws generally apply to overserving, because the calculus in determining whether or not the host is responsible is whether or not they could reasonably tell that this person was intoxicated. But there is an exception: minors. With minors, there are states in which the social host social responsibility rules apply with full force, regardless of whether it was overserving or not. That means that it isn't the case that a host needs to have reasonably known that this person was intoxicated, and that's when liability could attach or duty could attach. No, it's enough that this person served a minor, even if it wasn't overserving. And if that minor went out and did something stupid and hurt somebody, then that host could be liable. Every April around prom season, you read stories in the paper about how a group of teens went to somebody's house after prom, and parents were there, and parents were involved in serving alcohol. And then a couple of drunk teens doing what drunk teens do got in a car and did something stupid, and somebody got hurt, somebody got killed. And the question is always, are these parents responsible? Are they liable? And in states that have those types of social host, social responsibility laws, the parents who served the alcohol could very well end up being liable for this injury that somebody else suffered because somebody else got in a car and hit them, because the parents were the ones who served the alcohol to the minors who went and foreseeably did something stupid that caused harm. Say you're not serving minors and you're not overserving your guests. Are there other ways in which you could potentially be liable? Absolutely. Assume it's your house. You are a premises owner. In the law, being a premises owner has a very special duty that goes along with it. You suddenly have a responsibility to the people who come onto your property. Now, the law historically looked at people who come onto property in 3 different ways. They categorized them as invitees, people who are invited onto the property, like the people at your party. Licensees, more like tenants or commercial establishments that are operating on your property. and trespassers, people who come onto your property but they weren't invited. Over time, a bunch of jurisdictions have done away with those kind of discrete roles and now look at everything, people coming onto property, through the lens of foreseeability. But those roles are helpful in kind of thinking through what is and isn't foreseeable, because that's how this was looked at in common law, way back when. Premises owners have the highest duty to invitees. They have the duty to make sure that any hazards, known or unknown, are taken care of. They've got to fix and warn of hazards. So, fix that front porch step before your guests come, because it's going to be dark and they'll trip. Or as soon as they walk in the door, say, hey, by the way, you should know the step over there next to the bathroom is a little bit janky and you may trip on it. So be careful, fix or warn known hazards. And premises owners generally have a duty to check and do sort of inspections for other hazards that may not be known or readily apparent. So keep looking through for spilled drinks, making sure there's no slipping hazard. Making sure that lights aren't going out in areas that become dark and then unsafe. Premises owners have a fairly high duty to invitees to protect them against hazards that are associated with the premises. Premises owners even have some level of duty to trespassers, uninvited guests. At common law, that duty was generally limited to what's called the booby trap rule. You can't set traps for trespassers. I read a post recently on Reddit about a farmer in Canada who had set up some tripwire or fishing wire between trees on their property because people were riding dirt bikes through the property. And so this was to deter dirt bikers from going through the property. That is a great example of a trap, a booby trap. Because if somebody were to ride through that property and go into that fishing wire, something terrible would happen to them. The premises owners at common law had a duty to protect against booby traps and not set up booby traps for trespassers. In some jurisdictions, there can be a duty to warn trespassers in the same way you would warn invitees just of dangerous conditions or hazards on the property if the premises owner reasonably knows that trespassers use that part of the property regularly. So like a shortcut through somebody's yard, or maybe the dirt bike example where somebody knows that people cut through on dirt bikes often. Using that regularly by the public or by certain groups of people may create a duty, if the landowner reasonably knows about it, to warn them of hazards. As a party host, you might be most interested about the duty to warn or protect against attractive nuisances. Attractive nuisance is a common law doctrine that says if there's something on your property that is reasonably likely to attract children, like a pool, then you have a duty to take steps to make sure that it is safe. And if you don't, then you could be liable if a child trespasses onto your property to play with, to engage in that attractive nuisance, and is injured. Classic example, unfenced, uncovered, ungated pool on a property. Kids walk onto the property, use the pool, kid drowns, premises owner could be liable because it was an attractive nuisance. It was reasonably foreseeable that children would come onto the property to use it. And without any kind of protective measures or warnings, they breached their duty to keep it safe. Duty is all about the ways we as a society choose to allocate risk and burden. We want to make sure that as a society, we are protecting children and that we are making sure that adults bear the burden of protecting children. And the attractive nuisance doctrine is one of the ways society has chosen to do that in the context of legal duty and liability. Suppose everything was above board. Everybody had one drink only. There was no tripping hazard. You cleaned everything up. Your guests are having a nice time. And all of a sudden, two of them get into an argument. And then it escalates. And one of them punches the other one in the face. How could you be liable for that? Well, premises owners can actually be liable for third-party assaults that happen on the property. There are two big aspects to that potential liability. Duty, which is, was it reasonably foreseeable that this third-party assault could happen? And then breach. Did the owner do everything that they should have done? Did they meet their standard of care? Did they act reasonably in making sure that they addressed any foreseeable risks? Now, if the host invited somebody who they knew got violent when they had one drink and they served them a drink, well, then it could be foreseeable that that person was going to get violent with someone at the party. That could be a situation where there might be a duty to protect against third-party assaults by that individual. How could the host have done that? They could have not invited the person. They could have not served the person alcohol. They could have been on the lookout and jumped in to de-escalate the situation. There are a lot of things that could have been done. It's a highly fact-specific circumstance, and it'll also change depending on who the premises owner is. There are cases in which, like, shopping malls have been found to have a duty to protect against crimes, muggings that happen in a parking garage. That's a situation where what could the shopping mall have done? They could have had more lighting. They could have security guards. Those are going to be very different in the context of a party in somebody's home. But the things to remember are, was it reasonably foreseeable? And if it was, did you take steps to act in a reasonable way to prevent it from happening? Now, I don't want folks to get scared that they could be liable for anything that happens no matter what. That's just not the case. These are all relatively high bars. Imposing a duty is not easy. Finding breach is not easy. It requires someone to have acted unreasonably. Causation is also required, that the breach of that duty caused the harm, and then there has to be actual harm. So you have to meet a lot of elements to show liability. And it isn't the case that every host of a party, every person is an insurer of safety. But there are rules that can make hosts of parties more responsible than the average person on the street as it pertains to harm that could arise from something that happened at the party, whether it's to the guests, to uninvited guests, to people outside who are harmed by the guests because of what happened at the party. There are potential liabilities. Now, if you're curious to learn more about that duty, breach, causation, harm elements of negligence when somebody is liable for action or inaction, then check out this video I did on negligence. I think you'll find it interesting. Otherwise, thanks for sticking around, and I'll see you next time.